Welcome, everybody. We are super lucky today to have with us Melanie Ash, Senior Counsel of the Affirmative Litigation Division of the New York City Law Department. And before we start, I want everyone to see a little video clip of our special guest today.
Alumni Award of Distinction. Melanie Ash has served as General Counsel to the New York City Racial Justice Commission since 2021, on loan from the New York City Law Department, where she serves as Deputy Chief of the Affirmative Litigation Division. Her work for the Commission is dedicated to uprooting structural racism in local government. Melanie, who completed an LLB at UBC in 1996 and an LLM at Columbia University in 2000, has been repeatedly recognized for her extraordinary work promoting social and economic justice.
One of the most critical things that helped me to get through law school and to continue on my journey was the support of the Black Law Students Association of Canada. We started a chapter of that at UBC while I was there, and it was a real source of support, of comfort, of mentoring, of companionship, and just a really wonderful experience. Being one of the very few Black students at the school was a challenge, and I think having that support network is really important. And I was excited by the thought of using the law to really define the rights, to expand on the rights that Canadians were receiving under the Charter.
Melanie has passion, dedication, and intelligence. She has incredible strength of character and sense of purpose. And these traits combined ensure her success and the impact that she can have in society. Melanie has been a great inspiration to me personally over the course of our careers, and I am delighted and so fortunate to be able to call her my friend.
One of the expressions that I like in the civil rights movement is that we stand on the shoulders of those who came before us. And so, I think that I would say to young people coming up, young lawyers coming up, that they should do that. They should stand on the shoulders of the people who came before them. And then when they get to that point where they've accomplished things and they've become a lawyer, and continue the chain forward until we reach the society that we're all striving for.
Melanie Ash, welcome to the show.
Thank you very much.
No, thank you very much. And when I read about the Allard Award, it was for your achievements in bringing honor to the law school. After I've read about you, I think you've brought honor to the profession, and we thank you for that. You. Okay.
Thank you very much. That's very nice of you to say.
All right. Your career epitomizes this show. It is clearly an adventure in law. And I'm sure it's been quite the journey, growing up in Kamloops, to being a page in the House of Commons, to clerking for Madam Justice McLachlin, the Supreme Court of Canada, and now in the New York Affirmative Litigation Division. You're described, Melanie, as a justice seeker and a change maker. And where did this all begin? And when did you start knowing that you wanted to make such a difference?
Well, I was raised in a family of I would say change makers, justice seekers. Both of my parents were very much activists in their fields and leaders in their fields, and union members, union leaders. So I sort of grew up with activism and marching at protests in my blood. And that's one of the things that led me to law. I sort of watched the way that law can be used as an agent of social change. And that kind of was what excited me about the law. So that's sort of where I came from. And I've tried to carry on that tradition. I was also raised as a public servant to believe in the importance of serving the public in government. And so that's just the path that felt most natural and most like me.
And when I was reading about you, I wondered, how did your career and your legal journey end up in New York City? What was it about New York City? What was your connection, your attachment? I wondered that.
Yeah, originally I came to New York to go to graduate school. I came to do an LLM. I was thinking about teaching law. That was my goal when I applied for the program and I came down here. something about the city just got into my blood. I really love the city. I've always loved big cities, but and you know, New York, people who've lived here, even people who visited here will know you either love New York or it's not for you. You know, you sort of think, enjoy the moment, enjoy having the experience, but you're ready to go back somewhere smaller. I love New York. I love the energy. In terms of the practice, I love the complicated nature of the types of cases you get to work on, the academic, the intellectual challenge, the everything about it. And so I loved it so much, I decided I wanted to try to practice law here.
How about the rent?
I don't love that quite so much. But I mean, honestly, Vancouver's not that different right now.
Okay. Prior to your current position as senior counsel in the Affirmative Litigation Department division, you were general counsel for New York City's Racial Justice Commission. Can you tell us about your role there?
Sure. Well, the Racial Justice Commission was a charter revision commission, which is a creature of state statute. It's established to allow the potential revision of the New York City Charter, which is like the city's constitution. And they can be appointed by mayors or by the city council. In this case, it was a mayoral appointment to the commission was a mayoral appointed commission. And it was charged with trying to explore ways to uproot structural racism in New York City's city government. And as a member of the law department, I was offered the opportunity to go on loan basically to the commission and do the work of the general counsel, which is sort of a combination of standard general counsel like compliance, privacy, FOIL, those types of issues that any general counsel might see in their practice, as well as helping to draft legislation that would be enacted if the city, the voters of the city of New York chose to accept the proposals that the commission presented. So I was serving, helping them to vet the proposals. Were they legal? Were they constitutional? Could this be done? How could we do it? Drafting those proposals, drafting ballot questions, and then helping to guide them through the education campaign that led up to the election, which was in November of 2022.
And in your current role as senior counsel to the Affirmative Litigation Division, what types of cases does the division prosecute and defend?
Well, most of our cases, the vast majority, we are on offense, I'd like to say. We're the plaintiff's lawyers for the city. So any type of case where the city might have a claim to bring, we would be the ones asked to bring it. And so that could be anything from a contract dispute to property damage, to something constitutional, to enforcing city local laws, human rights laws. So it's the full breadth of things that you might think might happen, might require the city to sue. We would be the ones bringing those cases.
We are all aware of the prevalence of guns in the United States, which have been an ongoing issue, I take it, in New York City for some time. And you were counsel in a ghost gun case filed in the well-known Southern District, I believe in 2022. Was that the correct year? And it was an injunction application
Yes.
at first instance. And as I understand it, and correct me if I'm wrong, Melanie, ghost guns are sold online. There are no serial numbers, and they are described as unfinished, meaning that they come in components, which are ultimately put together by the purchaser, and background checks are not required. Is that an apt description of a ghost gun?
Yeah, that's right. Yep.
Okay. And they're obviously sold, to use your words in the brief, to evade gun control laws.
Yeah, I mean, I think they're ghosts because they're untraceable. You know, most guns are traced through their serial number and through the sort of paperwork that has to be filed when you purchase them. And so ghost guns are secret and hidden and easy to conceal because they have no serial numbers and they are not registered through the regular firearms registration system.
And the prevalence of ghost guns, and I read this in your brief, are about 10% of the guns recovered in New York City are unfinished or ghost guns. And in the 5 years between 2016 and 2021, more than 45,000 ghost guns were recovered federally.
Yeah, they're a growing problem. And I think so when they're purchased, they're unfinished, and then the purchaser can spend, maybe a half hour to an hour, depends how adept they are, in their home, doing a little bit of drilling, a little bit of sanding, and then they put it together and they have a finished, usable, functional firearm. So they're purchased as unfinished, and then they are finished as part of the process that the buyer does.
And your brief, in part, states countless more remain on the streets or in homes, unlicensed, untraceable, and invisible to law enforcement. Now, one of the questions I had, do both federal and New York state law prohibit the sale and possession of these types of guns?
Well, it's actually an area of the law that's in flux. They are absolutely illegal in New York City and in New York State. More recently, there's been some new regulations around them in the federal government, by the federal government, that are under attack. They're sort of subject to some litigation right now. So they're not illegal in the federal government, but they are, if the regulations survive the new regulations survive the litigation challenge, they will be required to be serialized, meaning someone will have to put a serial number on them, and they will have to comply with the standard gun control rules in the United States. Whereas in New York City and New York State, the components and then the finished guns themselves are illegal.
What I wondered when reading the brief that you prepared was, why was an injunction applied for under the New York City public nuisance laws and the common law when there were already state laws against the possession and sale of these guns? Why wasn't there enforcement of the state laws as opposed to you having to apply for these guns being a public nuisance?
Well, so the guns themselves in the hands of the possessor or the purchaser are absolutely enforced to the extent that the police are able to locate them. They enforce those laws against the producer. This was an attempt to enforce against the seller, and none of the sellers are resident in New York City. So New York City police has no jurisdiction outside of its borders, and so it doesn't have the ability to go and enforce them against the seller who's in another state. So this is a way to use the tools of the law to put an injunction on the sellers, prevent them from selling them, using the jurisdiction of the courts.
Okay. An injunction was issued, is that right?
So it's a little bit complicated. Against one of the 5 dealers that were sued, an injunction was issued. The other 4 voluntarily agreed to a settlement with us, where they basically agreed to cease selling.
All right. And you argued this case in front of the court, is that right?
Yes, it was a telephone conference. These days in the world of the pandemic, I think we all experienced this probably, but it was a telephone conference in front of the court. That's right.
Okay. And so where does that case stand now after the injunction was issued?
So now so that was a preliminary injunction. So we now have to try the case on the merits with respect to the one remaining defendant. The sort of weird glitch right now is that the defendant's lawyer has withdrawn. And so now we're waiting for them to get a new lawyer or face default, because in the federal courts in the US, you can't be unrepresented. A company cannot be unrepresented. You can't represent yourself. You have to have a lawyer. So we're sort of in a holding pattern where we have moved for default because they have failed to get a lawyer, and they have a period of time to respond to that.
So what would normally be the next step in the US courts?
Well, we would normally litigate the case. So in a preliminary injunction, the test is, are you likely to succeed on the merits? That's one piece of the test. Is there irreparable harm? Are you likely to succeed on the merits? So you get the preliminary injunction, and then you have to go actually litigate the merits. Now, the court has obviously found by giving you the injunction that you're likely to succeed on the merits, but you still have to put your case in. So you go into discovery and you do sort of standard litigation.
Another seminal case that you were involved in, Melanie, was the state of New York, New York City, and the states of Connecticut and Vermont, against the Department of Homeland Security. And in that case, a federal law was challenged prohibiting non-citizens from entering the US if they were to become a public charge, meaning that they would be utilizing government benefits. Can you tell us a bit about that case?
Yeah, the public charge rule is sort of a longstanding rule that has always been interpreted and applied to say that if you are going to be fully and completely dependent on the government, you can't immigrate into the United States. So not the occasional use of some benefits, but if you're going to be fully dependent on the government for all to survive, essentially, that's considered to be being a public charge. So the Trump administration put in place a new rule, which was going to expand greatly the way in which public charge would be understood. So to include things like food stamps, to include use of public health care, any receipt of dollars. Is sort of much broader than it had been. And at a time when we're in the midst of a pandemic, it was tremendously important to the city of New York that people be able to use public benefits like the public healthcare system to get vaccinated, to actually be treated for COVID. And so the lawsuit sort of came right before the pandemic and then sort of accelerated during the pandemic when there was this tremendous concern that immigrants, undocumented immigrants, but all immigrants really tended to be the engine that kept a lot of these city running in terms of service industry, in terms of deliveries and things like that, were not going to get access to healthcare and would be more likely to be ill than others because of the way they were serving the public. And so that was sort of an urgent case during the pandemic for those reasons, but it related to, so we were challenging that interpretation of the public charge and that law, which we said would have expanded the public charge dangerously to prevent people from getting care when they needed it.
Excluding COVID medical treatment, is that right?
Yeah, among public COVID medical treatment that would have been on the public, like sort of using the public system, using the free public healthcare system. So which is the sort of the system of last resort.
And where does that case stand today?
Well, that's it. We did get an injunction. So the interesting thing about this case and a lot of cases that were brought against the Trump administration is that there were a series of cities and states that all brought the same case in different jurisdictions. So this was one of those, and there were cases in the Ninth Circuit, which is sort of California, Washington State, Oregon, and then there were cases in the Fifth Circuit, which is sort of the middle of the states, like Chicago area, all at the same time in different courts. And so in our case, we did get an injunction based on COVID. There were appeals proceeding. Similar in the other cases, they also got injunctions. One of the courts in the middle of the country vacated the law, struck it down nationwide. And then the new administration came in, they repealed the law and they passed their own law. So it's one of those things where it's caught up in the change of administrations from the Trump administration to the Biden administration. So the case is sort of stayed right now, given the changing dynamics of what happened just before the administration and after the administration changed.
The third very interesting and I thought very creative case, and I think this is one where your division defended as opposed to pursued,
okay,
was an action against the city for violating federal and state laws by denying homeless students living in shelters a sound basic education by failing to provide internet services in the shelters. And I thought whoever brought that, it was brilliant and creative. And I was wondering why the city in any way defended that.
I think that the interesting thing in that case was that there was very little indifference of position between the city and the plaintiff. And the city, when the issue became apparent, when it became apparent that children living in shelters were really going to struggle to do remote education because of the lack of internet, the city bought like 1 million iPads with internet access and distributed them to students. But as all of us know, the Wi-Fi connection and the strength of our cell phones in different parts of the city can vary greatly. And you might not have great service because of the size of the buildings. And so there were problems with the service. But that was sort of a stopgap measure that the city put in place while it did the work of putting Wi-Fi in shelters. So there was always an agreement by the city, we're going to put Wi-Fi in the shelters. There was a disagreement was really about how would it be done, what sort of method, and how quickly could it be accomplished. We had like 500 shelter buildings housing, tens of thousands of families, many of which were old and had zero wiring whatsoever. So it was a question of how quickly can we put this and roll this out all over the city? And that was really what the dispute was. And I think the goal was always on both sides to get Wi-Fi into the shelters. It was really a dispute about what would be the most effective way to do it, most cost effective for the future, the most robust, so that could sustain the actual students. And we felt, and our experts said, that doing a sort of shared Wi-Fi model would not be effective because it's not robust enough. If many families are using the same Wi-Fi, it's sort of like, and if you're in a hotel, the Wi-Fi is not good. Everybody knows you can't use Wi-Fi that well in a hotel where 100 people are using the same Wi-Fi. So we opted to go with an in-room. Every single unit was going to get its own independent Wi-Fi, similar to what your apartment would have at home or your house. But that was the dispute. It was over the time it would take us and whether our proposed method was better than their proposed method or vice versa.
That's the kind of case where you can see the results, and that must be nice.
Yeah, I mean, I think we all felt really strongly that it was critical to get that Wi-Fi in, and it was really rewarding to know that we got a robust system up that's going to keep families for the next generations who are in shelters.
Sometimes we go through our careers and we say to ourselves, have we made a difference? But I think that was one clear case where a difference was made.
Yeah, no, I absolutely agree with you. Yeah, and it was, I think the thing that we felt really great about was just how committed we all were to the solution, finding a solution. I think on both sides of the V, we were committed to finding a solution. We disagreed over exactly what that looked like, but we reached a settlement where we both felt we were going to put in place a temporary measure that would get those children the education they deserve, allow them to reach remotely, join the school system, as well as put in something that was going to be useful for generations to come and would benefit homeless shelter families in homeless shelters. So it was actually a really rewarding case, although crazy and high stress because it was all in a very condensed period of time.
Are there any other cases that come to mind where you really feel good about making a difference?
I mean, I've previously brought gun cases that were public nuisance cases, and I think I felt really great about those cases because we actually did studies that showed that and those cases were around trying to stop trafficking from gun stores that are trafficking guns into New York City, because with our stricter gun laws, sort of similar to tobacco or cigarette smuggling, the way things work is that cities or states with less strict gun laws, the guns will be bought there and then they will be trafficked into New York City. And we developed an innovative case which greatly reduced the trafficking of guns from certain stores that were the highest sort of targets of traffickers to buy from. So that felt really good. That was another example. But I see them all the time, even to the point where, let's say I had a case where somebody poured cement into the concrete into the sewer by accident, we believe. But in the end, the cost to the city was massive, but it was also a cost of, overflowing sewers into the subway system and just creating a huge mess and getting a result where the city is reimbursed for the, however many $1 million it had to spend to fix that problem that was not the city's making. Yeah. That's rewarding too.
It's kind of like putting sugar in somebody's gas tank, but at a much larger level.
Yeah. And if the gas tank spewed sewage, then yes.
Okay. So what other interesting cases can we expect from your division? Are there any in the works we can know about?
I mean, I think I have a case that I'm excited about that involves what's called the Freelance Isn't Free Act, which is a brand new statute in New York City, first of its kind in the nation, to protect freelancers who are not getting paid on time or at all for the work they're doing. And we all know the sort of gig market is a huge booming market. And so it's important that freelancers get protected from unscrupulous dealings. And so we have this law in place, and I'm doing the first pattern or practice case under that statute, which I'm really excited about. I think it's an important statute as the changing workplace situation, moves forward. We have to be able to respond to it and protect workers who are they're not eligible for regular employment protections because they're not employed. They're temporary contractors.
Now, the next set of questions, and I warned you before, Melanie, were generated by artificial intelligence. And I can assure you and everybody that I did not put the facts in to generate these questions because I wouldn't know how. Okay.
Okay.
Okay. So first artificial intelligence question. What legal strategies have you found to be the most effective in advocating for social justice?
Legal strategies. Geez, these are complicated questions. I think I think being creative is one of the most important. I think you pointed to it when you said the way in which that one case was argued was very creative. I think when you're working for social justice, you have to be using the tools and be willing to use the tools in the most creative way possible by bringing cases that have never been brought before, pushing for broader interpretations of laws to make sure that they're as effective and broad-reaching as they can be. So I think, your creativity hat is what's probably one of the most important things when you're working on social justice cases.
And what are the biggest legal obstacles to achieving social justice? I'm usually not this philosophical,
I was like, these are definitely AI questions. They're just repeating social justice with different first parts of the question. The obstacles, I think you're going to see everything from, when you're a lot of times with the social justice, as I mentioned, you're sort of trying to push the boundaries. So you're thinking outside the box, but the box is what maybe is the traditional way and what the courts are expecting and what the courts are requiring. So I think one of the biggest challenges is just not having a precedent for where you could go and whether this can be acceptable or not. I guess another one would be potential backlash. I think we're seeing nationwide, citywide, worldwide, we're seeing backlash against social justice movements. I think that happens regularly. There's traditional backlash after there's improvement and progress. So the backlash is really real, and I think that's probably one of the main problems right now.
And probably the most relevant question to what we're doing here, coming from AI, was what advice would you give to young lawyers interested in pursuing a career in activism and law?
I would say that, I know a lot of people feel when they're in law school that you have to do the sort of standard courses. Everybody's got to do the same black letter law courses. I'm of the view you should take the courses that you're passionate about, that excite you, and that goes especially with social justice type courses. I think when we're hiring someone, and when someone is hiring someone to do that kind of work, they want to see that you're not coming to it just 5 minutes ago. They want to see you've put in the work, you've thought about the issues, you've taken the classes, you've maybe spent your summer or one of your summers doing that type of work rather than only doing traditional legal practice. So I think putting in the work, showing the commitment to the topic is important. Taking those opportunities when they come, I think, networking, finding connections, meeting other people doing that work and doing informational interviews with them to learn how did you get where you are. There are a lot of different paths into the type of work, so there's not just one way to do it. You can go from a traditional practice into a social justice type practice, and I would say the way to sort of move in that direction might be through your pro bono work. You're spending some of your time outside of your regular hours learning about it from practitioners by donating your time as a volunteer. And I think that is also very highly regarded.
We're leaving the AI questions, artificial intelligence, and going to my lack of intelligence questions, okay? Is it difficult? I've always wanted to ask somebody this. Is it difficult to transition from practicing law in Canada to the USA, both in and out of court? It seems so different.
You know, I mean, in the grand scheme of things, it's more similar than it is different because it's common law systems. They're both common law systems. The US has more statutory provisions than Canada, but they're based on that same tradition. So I think in that sense, it's familiar. The US law is more, the constitutional law is very different. So yeah, there are a lot of areas of difference, but I think if you study for the bar exam, which you'll have to do if you're going to practice in the US, you'll learn a fair bit if you really put in the work of learning it, not just memorizing what you might have to know for that test. I would encourage people to try to summer in the US because that's a good introduction. But yeah, it's a little bit different. It's a little bit more complicated. It adds another layer of work you have to do, I think. For me, doing the LLM was actually a really great way to immerse myself in US law before I started practicing. So I didn't face it in the same way I think a lot of people might face it if they're coming straight out of law school.
May I ask what was the most difficult part of the transition for you?
I mean, to the practice or to living in the US?
No, not living in the US, the transition from Canadian practicing in Canada to practicing in the USA, the most difficult part of the transition for you.
Yeah, I mean, I think I think the scope of the United States, the scope of the amount of law, the federal practice is a lot more robust in the US than in Canada, I would say. And on top of that, also the state practice. So I thought there was a lot more law to learn, I guess, was sort of one of the areas. And it was just in some of the key ways around civil procedure, it was very different. And so civil procedure is obviously that's the key area if you're practicing as a civil litigator. So I think that was probably the biggest challenge, was kind of getting my head around the different civil procedure rules and laws.
On a real practical level, what's the difference in being in a federal court, being an advocate in a federal court, and being an advocate in the Supreme Court here? What's the difference when you're in the courtroom?
I'm sorry, the question is what the difference between federal court in the US and Supreme Court in Canada, or?
No, just in a court in the US and a court in Canada. What's the difference when you're actually in the courtroom and arguing the case?
I mean, the robes, if you're doing a case there's no robes in the US, so you have more trouble deciding what you're going to wear, I guess. But yeah, I mean, I would say they're not that different. Personalities of the judges are the personalities of the judges. I mean, I think in both cases, you're getting very talented jurists who are well prepared and are going to fire questions at you. So I think they're not that dissimilar. The biggest difference probably is the clothing.
Okay. Canadian lawyers generally think that the style of their counterparts in the USA is much more aggressive. Is that true?
I would say no, it's not true. I mean, it can be, but I still think that probably the most aggressive in a negative way person I ever came up against was not in the US courts, it was in the Canadian courts. So I think they're very similar. Litigators are litigators, and I've seen aggressive in both courts, and I've seen really kind of friendly in both courts.
That's very diplomatic. All right, we're going to go to some rapid fire questions. You ready?
Okay. Rapid fire.
Don't be worried. They're easy.
Okay, I'll try not to.
Right. What's the favorite and most frustrating part of your current position?
Favorite and most frustrating. Favorite part is, I think, just being able to represent the city of New York, and a city that I am so connected to. I think I feel really privileged to be in this role. So the most frustrating part, I think, is just discovery. Discovery is frustrating everywhere, isn't it? Like document discovery, e-discovery, producing documents. I think that's probably the most frustrating thing that I don't enjoy that much.
Okay. If you were to do your career over again, would you do anything at all differently?
I might have tried a firm for one of my summer jobs when I was in law school. I never worked at a firm. The first firm I worked at was the one I stepped, I guess was post clerking. I might have gotten a taste of it in one of my summers after in law school. So I would just have a better sense of whether it was for me or not. And a little bit more experience. I wouldn't feel quite so intimidated by it when I first stepped into it as a lawyer, not knowing what I was getting into.
What are you currently reading or streaming? Or is the question that prefaces that, do you have time to do either?
Are you currently reading or streaming? I'm trying to remember the name of it. The one that this sort of sci-fi fungal thing that everybody's watching on HBO. The Last of Us. The Last of Us, I think it's called, which is like a zombie apocalypse type situation. That's what I'm currently streaming. Currently reading. I can't think of. Oh, I'm reading Conversations with Friends, which is a good novel. Conversations with Friends.
Okay. What's your favorite song of all time? You don't have to sing it, by the way.
All time. I mean, I would probably pick some. I don't know if I could narrow it down to one. I would pick something off of the Songs in the Key of Life Stevie Wonder album, which is, I think, one of the best of all time.
And what's your bucket list place to travel to next?
I want to go to, I think, Morocco.
Okay.
Heard fabulous things about Morocco.
What?
Just that it's beautiful, that the people are wonderful, just the culture, everything about it is wonderful.
Okay. Are you going to go?
I hope to go. I'm trying to line it up.
Okay. All right. What do you like best and least about New York City?
Best, I think I like that it's just the vibrant city it is, like that you can do anything and everything in New York City. It's available. It's probably maybe even 24 hours, but it's just it's got so much to offer. And what do I like least? I would say the standing water in the summer, the smelly standing water. That could be pretty good.
What's the favorite Broadway show that you've been to?
Hamilton, I think.
Hamilton, okay.
Yeah.
And lastly, what's your favorite restaurant in New York City? And I'm asking you because when I go there, I'm going to go to this restaurant, okay?
Well, I like all kinds of restaurants, but I would say I would probably put right up there Le Bernardin, which I think just got a couple Michelin stars again. It's a fish and seafood restaurant. Famous chef, like probably one of the best restaurants I've been to for sure.
Thank you, Melanie. I have today, I want to tell you, a Michelin star guest.
Oh.
Who
So
I am
nice.
very honored to have. And Melanie, it's just been a real pleasure. And I want to thank you for sending me those very interesting cases. I find them just phenomenal to read. And when I see your arguments, it made me feel very honored to be able to have you on my show today. So thank you
very much.
Very much. And I hope to see you when you're back in Vancouver. So thank you, everybody. In 2 weeks, we're going to have Mr. Dinyar Marsban and Mr. Jeffrey Kay together, and you will learn a whole lot about practice management and tips to having a very great legal career. Thank you, everybody. See you in 2 weeks, and thank you again, Melanie.